association. Yes, it's a membership association here in Tanzania. We are a body and the voice of data protection, privacy, cybersecurity, and all things technology here in Tanzania. We come together for many different occasions and engagements to learn more, to increase our knowledge, to increase our capacity and understanding on the matters of data protection, privacy, and cybersecurity. We have members from all sectors, ranging from university students, we have corporate officers, we have people in the legal sector, in the tech sector, in the academic sector, in the research sector, and we usually have a very good time together. We are growing in these fields of data protection, privacy, cybersecurity, and we are happy to have more people join us, and we conduct a number of engagements such as these webinars, publications, and many other fun events to make sure that we learn more and we are responsible in how we manage data protection and privacy. That is a little bit about us. The rest of our team from TPPA will be sharing more links during this meeting, and if you have any questions for us, please do not hesitate to reach out to us. I now invite our partners from Sandbox Security to also give us a little bit of a welcoming remark to tell us who they are, where they're based, and what work they do. I welcome Rahul. Rahul, welcome.
Thank you, Rachel. Good afternoon, everyone. Welcome to our webinar on the data protection and the complaint handling. As Rachel has mentioned, so we are a cybersecurity data privacy consulting firm. We work with a lot of fintech, BFSI sector, and different sector organizations. And the implementation of the data privacy, be it local regulatory requirement, which is coming from the GDPR or PDPL, or from Tanzania perspective, the privacy regulation, as well as we do implement ISO 27701 also. In a cybersecurity, so be it the cybersecurity maturity assessment, cybersecurity compliances. So we do have a cybersecurity unified compliance framework for the organization, where the organization, they have the multiple cybersecurity compliance requirement. We do implement that. Anything and everything which is coming from the offensive security domain, we do work with the organizations to perform the vulnerability assessment, penetration testing. We are also into the product, so we are having a very niche product that is on the AI vulnerability, AI red team, basically, which is largely how we can perform the red teaming on AI platforms, on your LLMs, your AI agent, as well as any other infrastructure which is from the AI perspective. So this is brief about Sandbox security. Over to you, Rachel.
Thank you. Thank you, Rahul. Thank you so much for telling us about Sandbox Security. And I see that the Sandbox Security team is here. Please do share a link in the chat section to your website, your social media pages, so that people can connect with you even after this webinar. Thank you so much.
Surely.
All right. All right. Ladies and gentlemen, please tell us where you're joining us from in the chat section. Please tell us what you'd like to learn about, what you'd like to hear today. We're very happy to see who's joining us, what work you do, where you are joining us from, and we will be having a very wonderful time here today. All right. And now I would like to give a little bit of an introduction about our topic today. As you have seen in the posters and in the announcements all over social media, we are looking at data protection, complaint handling, and decision enforcement. What does this mean? In short, we are learning about how issues,
You has joined the meeting.
we're learning about how issues can come up with data protection, especially in the protection of the rights of the data holder or the data subjects. And so when issues come up, when rights are violated, when rights are not enforced, what is to be done? Where is your starting point? Where do you go? How should you present your case and things like that? And then even as you are presenting your case, what steps should you take when a decision comes up after the decision has been made? But more importantly, we're also going to be discussing and learning about what organizations, companies, offices, what mechanisms they have in place or should put in place, how to protect the information and the data that they have. And so we are looking at a mindset that is more proactive rather than being reactive when an issue or a complaint comes up. In a nutshell, that is what our discussion is going to be about today. And we hope you will enjoy it. We hope you will come up with real life questions, examples, anything that may help today, so that by the time this webinar is done, you have received some more insight and more understanding of how data protection complaints are handled, how enforcement is done, and how compliance can be implemented in your day-to-day activities. Thank you once again. And we are happy to go right into the panel questions today. Please do allow me just very briefly to tell you about the speakers that we have with us today in just a quick moment. We will begin with Mr. Rahul. Just a quick moment. Oh, my apologies, my apologies. Please allow me to start with Please allow me to start with Advocate Abdul. Advocate Abdul is joining us from the United Republic of Tanzania, and I am happy to tell you just a little bit about what he does. Yes, so Advocate Abdul works at the intersection of litigation, intelligence, personal data protection, and institutional accountability. He serves currently as partner and head of data protection and litigation strategy at Robic Attorneys and Legal Consultants. He advises institutions navigating regulatory exposure, governance risk, and high stakes disputes. Most notably, his role is not merely to argue cases, but to shape outcomes before and beyond the courtroom. And then now on matters of data protection specifically, he works with institutions to build defensible systems, compliance frameworks that withstand regulatory scrutiny, institutional liability mapping, executive exposure mitigation, governance and policy design, and strategic dispute prevention. Advocate Abdul, are you here with us? Can you say a quick hello?
Yes, I'm here. Hello, everybody. As Lecho have already introduced me, I'm Advocate Abdul Said Naumanga, a partner from Robic Attorneys and Legal Consultants. Thank you so much, Lecho.
Thank you. Thank you so much. All right. Ladies and gentlemen, please allow me to read the bio from our next speaker. Just a very quick moment. All right. We have Mr. Rahul joining us from Sandbox Security. Rahul is a seasoned cybersecurity governance, risk and compliance expert with a wealth of experience in safeguarding organizations against cyber threats. With a multifaceted skill set, Rahul specializes in PCI DSS compliance, regulatory information security compliance, risk assessment, artificial intelligence governance, blockchain security, cybersecurity, defensive strategy, and internal security audits. In the realm of risk assessment, Rahul employs comprehensive methodologies to identify, assess, and mitigate potential risks to organizational assets. His strategy insists his strategy insights enable businesses to make informed decisions, prioritize security investments, and proactively address vulnerabilities before they can be exploited by malicious actors. Mr. Rahul has just given the welcoming remarks from Sandbox Security, but if you can just quickly give a quick wave once again to everyone in the audience.
Sure. Thank you, Rachel. Good afternoon, everyone.
Good afternoon. Good afternoon. Thank you for being here with us. Next, we have Madhup Bajpai. Madhup Bajpai is a cybersecurity governance, risk, and compliance expert with over 9 years of total experience, including 7+ years specializing in information security and GRC. Yes. With a focused skill set, Madhup specializes in PCI DSS, compliance, SWIFT CSP, regulatory information security, compliance, zero trust architecture, and internal security audits. Also, in the realm of risk assessment, MADOP employs comprehensive methodologies to identify, assess, and mitigate potential risks to organizational assets. So his experience spans working with e-commerce platforms, payment gateways, major banks in the Middle East, as well as power generating and manufacturing companies. He is adept at leading engagements for critical risk frameworks and presenting findings to C-suite leadership, ensuring that security strategies align with business objectives. Mada, please a quick hello to everyone in the audience.
Hi everyone, good afternoon.
Thank you so much. And last but not least, we have Advocate Sadiq Omari Sadiq. Please do allow me to quickly read his bio. Just a moment. My apologies, ladies and gentlemen. I'm going to quickly read his bio. May I just please quickly ask if Sadiq can quickly just come to my inbox? Just a moment. Apologies for that. But we are going to hear about Advocate Sadiq. Okay, ladies and gentlemen, apologies for that. I know Advocate Sadiq Omari Sadiq is working in Dodoma, Tanzania, which is the capital city of Tanzania. He is an advocate of the High Court of Tanzania, working at Goldmark Attorneys, and he specializes in data protection. He does a lot of litigation as well, and a lot of data protection, also data protection practice. And so he is here with us, and we are going to have a very engaging session with all of our speakers. Thank you so much, ladies and gentlemen. These are our speakers today. And without further ado, we will dive right into the panel questions right now. Our very first question goes to both speakers from the Tanzanian side and from the side of the United Arab Emirates. And the question is, what are the most common types of data protection complaints observed in both jurisdictions? And what do they indicate about emerging privacy and cybersecurity risk areas? From Tanzania, we will hear from Advocate Abdul Said Naumanga, and then from Sandbox Security, I believe we will be hearing from Rahul. Yes, all right. Let us begin with Mr. Rahul.
Sure. Thank you, Rachel. So, Rachel, I think that's a very interesting question. See, we are talking about two different countries, like one is Tanzania and second one is UAE, and what kind of complaints we are seeing in both the regions. So, I can definitely cover only from the UAE perspective, not from Tanzania. See, the biggest problem which we have seen, or the complaint which generally, we have seen it largely coming from the spam and pushy marketing. There are times like the organization, they are not able to understand, or it's somewhere it's difficult also to understand where they are spamming or pushing the marketing content from theirs, right? And the another problem which we can see the same thing, like there's no option for the customer for the clear opt-out mechanism. That is the first problem, the biggest problem I think, which we have seen in this region, which is spam and the pushy marketing. If we talk about the second complaint, which is again, coming largely in this particular region, Rachel, and everyone, that is largely coming from the non-compliances on the data subject access request. So most of the people, when they ask like, what kind of data do you have on me, the organization, they are not able to give the answer, right? So they are, because the data is scattered, they are not aware what kind of customer information they are having. So that's the another problem which we are receiving with the complaint which we are able to see it in this particular geography. The third problem, which is again largely related to the data governance, again I will see it, but the complaint which is coming from the data inaccuracy and the rectification, right? So there is no proper mechanism in the organization where they can give or they can take the complaint on the data inaccuracy or the rectification, which is something which we are facing in this particular region. The last but not the least, which I can think about right now, it from the notification on the data breach perspective. So if there is a data breach, the customer is not aware, like they are not having any notification from the organization perspective that the data is leaked. So these kind of the complaint which we have seen in this particular geography, I can say, Richard. Yeah.
Oh, thank you so much. Thank you so much. That is the perspective from the United Arab Emirates. And now Advocate Abdul is going to tell us about what it's like in Tanzania. What are the common types of complaints with this? Thank you. Abdul, you are on mute. You are still on mute. Okay.
I think now you hear me properly, Rachel.
Yes, I can hear you well. Yes.
Okay, as we all know that Tanzania have a new law. The law is very new here in Tanzania. We are just in the beginning stage, so we don't have a lot of complaints that have been already raised by either data subject. But the most commonly type that arise the complaint is the mixed type, because sometimes people they get a concern about the misuse of their personal data, but sometimes in the same complaint, you can find out that there is an authorization of disclosure, but also the issue of lack of consent and the transparency come across. So with this regard, two things emerge. We now understand that the awareness of people in Tanzania, they are still low, but regulatory, like PDPCs, they tried hard to make people understand what the personal data means, what the right people they have. But since there is a law and awareness, so even the complaint which goes to the to the either data controller themselves or to the PDPC as a regulator, they're still few. But on those few, most commonly type is misusing of personal data and unauthorization disclosure, together with the lack of consent and transparency. So there is a huge gap. The law here in Tanzania are very clear. It's providing a mechanism for that complaint handling, but the problem is the actual practice. In the actual phase of the issue is different, because people they are not well aware about the issues of personal data. Very few percent of Tanzanian people who are aware about the personal data. People they don't understand what that the personal data mean. In practice, the most common type of complaint we are facing is those three types that of misusing for personal data, lack of transparency and consent, and together with this unauthorized disclosure. But mostly, as I said before, they come up on the same complaint. So you can find out in the single complaint, you have different types of data breach. So I think that is the perspective earlier of Tanzania, because we are new and we are still in March. Thank you, Rachel.
Thank you. Thank you so much. Thank you so much. Ladies and gentlemen, please let us mute. Let us mute our mics so that we are able to be attentive during this webinar. Thank you so much. That has opened the floor for all of us to have a general understanding of the different types of data protection complaints, as we see in the United Arab Emirates and as we see in Tanzania. Once again, Tanzania data protection is still very new, very complex. And so I believe there are some things we will learn today from the United Arab Emirates and see how to apply best practices. Thank you so much. And Rahul, the next question is actually for you as well. And please do tell us, to what extent does cybersecurity maturity and data governance influence the volume or the increase or the severity of complaints received by organizations? And maybe for the lay person in the room, please do tell us what cybersecurity maturity means. Thank you so much.
Sure, sure, Rachel. So I think, Rachel, that's a very interesting question. We need to see it. It's directly, basically related to the volume of the complaint which we are receiving. So, see, when we say the cybersecurity maturity, it means the organization is having sufficient controls available for the data security perspective for the organization, for the data governance perspective in the organization, right? So when we talk about like the volume of the complaints, right? If the organization they are having the low maturity on the data governance, which is directly translated into the how the organization they are dealing with the customer data, how they're basically managing it, right? So the generally, the problems comes when the organization they are not able to find, like as I told previously, right? The organization is not aware like what kind of information they are having from the customer PII perspective, right? So that's difficult for them to understand and go back and give the response on the complaint, like what kind of data they are having, right? Which is directly associated with the data governance. If they are having the right data governance procedures and the framework available in the organization, they will be able to get this information easily. If we talk about the second thing, which is again related to cybersecurity, and we can say it, the data governance, right? Largely, it is aligned to the cybersecurity. See, the most of the organizations who are having the cybersecurity maturity available, they are having the monitoring control at least available from the data breach perspective, from the cybersecurity incident perspective, right? Where they are able to find out the any issues which is related to the data breaches or privacy. They are able to find out those issues early with their detection tool. While if the organization they are not having that maturity available, they not be identify once the customer complaint is coming. So that is again another point which is directly related to the data governance. This is in the cybersecurity as well as data governance perspective, that we always try to protect organization on their crown jewels. Okay, so when we talk about the crown jewels, it's about the customer information which they are having in their organization, right? So where it's very important that the organization should have some kind of data classification framework available. They should be able to know what kind of customer data they are having, what they are protecting. So if that is not available in the organization, if the organization is mature, they will be having some kind of data classification framework available, and they will be in a better position to protect that customer data. If any incident is happening, they will be able to understand the impact of that particular the incident. So I think these are the few areas where I can see it, like the data governance as well as the cybersecurity. They are directly aligned with the customer complaints in terms of the data privacy regulations.
Thank you. Thank you so much. And this is making us understand more that data protection does go hand in hand with cybersecurity, and it's very
Absolutely.
important. Mm.
Yeah.
Oh, thank you so much. Thank you so much.
In fact, Rachel, I want to add. So you see it any data privacy standard, be it GDPR or local PDP or any other country, right? They are having specific section on the data protection, how we are storing the customer data, how we are maintaining the customer data. Even if we talk about data minimization also, right? Somewhere it is directly related to the cybersecurity, where in cybersecurity we also talk about limiting our exposure, limiting our attack surface. So if we are not having the customer sensitive information, it means we are limiting our exposure, right? So the principles which are there in the privacy and cybersecurity, they are aligned, largely aligned, I will say.
Thank you for that. That's a very profound response, Rahul, and I really appreciate your explaining to us about cybersecurity and data governance and how they impact complaints that may come from clients or customers and data subjects. And now, please tell us a little bit more. What challenges do organizations face now in responding effectively to data protection complaints, particularly from a data visibility and even a security perspective? And there are several people here in the audience who may be data controllers, data collectors, even data processors, or working in different organizations and offices. What challenges do they face when it comes to responding effectively to data protection complaints? Thank you.
Right. So Rachel, so you mentioned about the from the let's try to see it from the perspective of the challenges, right? So the first problem, as you were talking about the data visibility, right? So as I mentioned, like if the organization is not having any data governance framework available, they may not be having the visibility what kind of customer data they are having. If the organization is not having the visibility itself, how they are going to respond to the complaint, right? The another big issue comes from the how the data is structured in the organization, whether they're having the structured data or the unstructured data, right? So what are the different areas or different, the system components they are having where their data is resides, whether they have the data in the structure format, which is on the database, it's on the email, it's on the chat, it's on the paper format, right? So that's the another problem where the organization is not sure what is their data repository is. If we try to see it from the complaint perspective, so a lot of the time we receive the complaint on the right to reserve perspective, right? Again, the same thing. If the organization they are not aware where the data is, how they are going to erase that data. Okay. Another problem will come from the rectification perspective. Again, if they are not aware what kind of data and where it is, they are not able to rectify the data, right? I briefly talk about in my last answer that data minimization principle, right, Rachel? So that's another thing. Again, the organization has to understand what data they need from the business process perspective. Okay, I think this is very important understanding which organization has to have. If they are not having the customer data at all, or if they are having minimum data, the complaint will automatically get reduced. Okay. The another problem largely comes from the cybersecurity control perspective. It's the two-way sword problem, I will say. So the organization has to think about if the data is encrypted and it is already it is not indexed, right? Then how the security team members they cannot see the data and subject access requests which are coming, which generally lead to the non-compliances with the transparency rules because they are not able to see the subject access request and they're not able to respond to it. So these are the few challenges which I can see, from the responding to effective data protection complaints, Rachel.
Oh, thank you. Thank you, Rahul, for that very wonderful breakdown. And ladies and gentlemen, as you are also listening to this, please do start sharing any comments you have in the chat section. We will be addressing all of them at the very end of this panel. Thank you so much for giving that wonderful breakdown, Rahul. And if you may, bear with me once again, the very next question for this part is also towards you, and it seeks to understand what role can technology, for example, monitoring tools, automated workflows, and security systems, what role can technology play in improving the complaint handling process or enforcement efficiency? What technologies can we think about can help improve in that process?
Yeah. So definitely one thing which we can see it from the DLP perspective, data leakage prevention perspective, which again one of the technology tool, right? So the protecting the customer PII going out from the organization. So most of the organization they are in the customer PII information, right? So how they can secure, because there can be accidental breach or there can be deliberate breach where you are disgruntled employee they themselves trying to send something outside, or there are malware who's trying to send some information outside, right? So we have to look from the implementation of the protection mechanisms where any customer sensitive information, if that is leaving the boundary of the organization, we should have some kind of controls available which can stop, which can protect that kind of information going out, right? See, another thing which we talk about the complaints, right? Where so this the topic of this webinar, the complaint, right? So let's see if the organization is having one or two complaints or maybe 100 complaints. It is easy to manage it manually, right? But when the organization grows, or it's a big organization where we are talking about maybe thousands complaint in a day, how we are going to do it manually? We cannot, of course, not possible, right? We need to have some kind of automated solutions available, kind of complaint management system that has to be there. In a similar way, if we talk about the cookies management, again, it's practically impossible for anyone to set and manage the cookies manually. You need to have the automated solutions available, right? So these are the few areas where I can see the technology has to be the part of the data privacy framework implementation. Without that, yes, it is implemented, but may not be that effective.
All right, all right. Well understood, Rahul. If you have any links, websites, or places with such tools that anyone could learn from or maybe check out some more, please do feel free to share them in the chat section.
Surely.
Yes, for people to learn. There may be something that someone has never seen or heard of, but it could be a tool or a website that could help with such processes. Thank you very much. I will not tire you with any more questions for now. There is one more question for you, but we will keep it towards the end because it sits well with our conclusion for today's panel.
Surely.
Yes. And now we move to our next question again, which looks at the comparative analysis between Tanzania and the United Arab Emirates. We come to you, Madhu and Abdul. Please do tell us how complaint handling mechanisms differ in practice between Tanzania and the United Arab Emirates, and paying close attention to accessibility, response timelines, and operational effectiveness. Yes. Madhup, you're welcome, and then we'll hear from Abdul.
Sure. Thanks, Rachel. So yeah, I'll start with the UAE side, and I'll try to touch briefly on what I understand about Tanzania, and I'll let Abdul handle that part of the things because he knows about what's happening on the ground. So yeah, starting with the UAE, UAE basically has a layered system, and that is something that is important to understand upfront. So at the federal level, basically all the complaints go to the UAE data office under the PDPL. But we also have the DIFC, which is Dubai International Financial Center, which has its own commissioner of data protection. And we have the ADGM in Abu Dhabi, which has its own separate regulation. So depending on where the controller sits, the route is different. When it comes to accessibility, for all the complaints in UAE, it can be filed online. The DIFC commissioner has a well-known portal where data subjects can submit complaints directly, whether in English, and I believe there's no filing fee the last time I checked. Now, the federal data office similarly accepts complaints through the digital channel. So the entry point is generally very low friction. On the timelines for DIFC, it typically acknowledges all the complaints quickly and then aims to assess it within a few weeks through resolution, and depends on and it primarily depends on the issue as well. The federal framework also gives the data office discretion on how to handle and refer matters as well. Now, when we look at Tanzania from the outside, what stands out most is the complaint settlement regulation under the PDPA 2022 is quite structured. The PDPC actually has an online complaint system, wherein I believe the complaints can be filed in either English or Swahili, or interestingly, I think there's a feature where you can submit the complaint orally as well, which I believe from the accessibility perspective is a very great feature. And I believe on the timelines, the regulation sets out a 90-day investigation window, which is also, again, extendable by another 90 days. But yeah, I'd let Abdul take over and give us some more on-the-ground information on how the complaints are managed.
Okay. In Tanzania perspective, on the what it is on the ground, the law is very clear. The law have already created a very clear structure on how people they can raise a complaint, on which is started with the organization. The entry point is on the organization. You can go directly to the data controller or data processor. There is a certain right under the PDPA, particularly in Part 6, which provides several rights for data subject. And on Part 3 of personal data collecting and processing regulation, It provides a clear procedure on how a person can invoke those rights. So the beginning point is from a data controller and a data subject. It's either a controller or processor with a data subject. That is a key entry point. Though you can also it might happen a person you can go directly to the PDPC. It depends because even on those rights there is no a clear. It's not all right that have a clear procedure and mechanism to invoke them. It is few rights which have a clear mechanism to invoke them. But in terms of accessibility, as I said before, personal data industry in Tanzania is very new. So even the venue itself, example, a PDPC venue, it is only once in Tanzania. It's only set up in Dodoma. And there is no any other venue, so a person which can go there to. But it's also easy to be accessible because the mechanism are both formal and informal. But and also there is some which a person can do it online. Example, a complaint itself, form number 1, it accessible through online through PDPC website. If a person go just write a pdpc.co.tz, then you see there is a complaint item there, so you can file a complaint through the online system. But as we know, this accessibility it goes together with a matter of awareness. But since here in Tanzania, the awareness is still low, even people to understand that the accessibility of personal data protection also is low. People, they don't know how to engage with PDPC. And this is even to the practitioners. But also in time response, this is a very, very big challenge. I can give a actual example in my case, because I have already filed one case of myself to PDPC. But you may find out the only clear channel to respond for them is through email. But you can send it the email today, and you'll receive the response even after 2 or 3 weeks. And sometimes you didn't even receive a response. So instead, you have to make a follow-up and a follow-up and a follow-up so that your thing can go. So in response, there is a clear timeline in the law, but in real practice, that timeline, eventually they are not follow that timeline. It's a matter of follow-up and of a person, if data subject, him or herself, to make a follow-up through PDPC in several times, mostly through emails and calls. And also in perspective of sorry, Rachel, if you can you can remind me the question. I remember only on the timeline and the accessibility. What else?
Yes, there was accessibility, response timelines, and operational effectiveness.
Okay, on the matter of operational effectiveness, as I have already said it before, if you look at our law, the law is very clear. But here I can give you another example also. There is a lack of link between institution with the institution. Example, between PDPC itself, the Personal Data Protection Commission, with the judiciary. There is a lack of link between these two institutions, because the law itself, it's very clear that when a person, when the PDPC have already reached to the determination and they offer the award, then a data subject can enforce that award only through the judicial processes, through a court. But there is no our court here in Tanzania, the system of the court, we're using the e-case management system. There is no room for cases from PDPC. There is a room from other sectors and other types of cases, but the cases from PDPC, there is no room to initiate that, what we can say, an enforcement of award or an execution of that award. So there is lack of an efficient in practice, but in law itself, it is very clear. So I think that is enough for now, Rachel.
Thank you. Thank you. Very well received from both Abdul and Madhup. Thank you so much for the comparative analysis, showing us what's happening in both jurisdictions. And the next question is actually for you, Madhu. After looking at how the complaint handling mechanisms function in the United Arab Emirates, now please do tell us a little bit about how can collaboration between regulators, organizations, and even cybersecurity experts enhance complaints resolution, investigation, and enforcement outcomes. You have heard Abdul here mention about with Tanzania, for example, you have the commission, and then you need to tie in with the judiciary and all these other different elements. Is it like that in the United Arab Emirates? How are these different entities collaborating, or what can they do to collaborate in the whole process of complaint resolution, enforcement, and compliance? Thank you.
Yeah, so that is a good point, Rachel. So honestly, when we talk about complaint resolution, it's rarely a single party effort, and collaboration matters a lot. So when we talk about the regulators and our organizations, DIFC, we have seen when we've seen a DIFC do some collaboration with the organization, and usually the commissioner they interact and they engage with the industry on a let's say a regular basis, and before a complaint becomes a formal dispute, it really helps keeping an open channel for the organizations to engage with the regulators before it gets escalated. Now, when we talk about cybersecurity experts, we definitely need to engage them whenever a complaint comes in, because most of the time, as you might have heard Rahul mention, right, that when somebody complains that they want a certain type of data of let's say a data subject to be deleted, organizations don't know where that data is or how that data is structured. So that's where most of the times, whenever you have a complaint come in, there's an underlying technical layer underneath all of those complaints, and that's why we need to engage security experts as well, to make sure that everything is done properly, and at the end they have a better grounded solution or conclusion. Now, when we talk about information sharing, I believe it's happening a little bit when we talk about the UAE, but it definitely helps when peer banks speak to each other and tell them about their lessons learned from the incidents that might have happened, so that those same mistakes are not repeated by their peers or any other organization. So that is definitely something that would help with complaint resolutions as well. So to summarize in a short version, collaboration basically moves complaints from being adversarial to being a learning loop, and that ends up being better for everyone.
I like that. I really like that. Moving it from being adversarial to becoming more of a learning fragment. I really like that. And thank you so much. I was just looking into the DIFC. This is the Dubai International Financial Center, correct? Okay,
Yes.
okay. Wonderful. I'm sure members in our audience who are not familiar with that may like to know more about it. If you have a moment throughout this webinar, perhaps you could share a link with us about the IFC for people to know. Thank you so much. Collaboration is key. It's important. There's already a question in the chat section. We will come to address it later. It's directed to Rahul. But I do encourage everyone else to keep preparing your comments and your questions, because this is very important what we are discussing. And we have wonderful experts here on our panel and in the room. We will be able to get our answers. Please, if you had a burning question about your organization or about a complaint that has come to you, this is the space. You can start to get some answers and responses here. All right, as we move on to the last part of our panel for today, as we're getting ready to wrap up, there is a question for, yes, there is a question for Abdul. Abdul, so Madep has spoken to us about collaboration between regulators, cybersecurity experts. Yes, but now let's talk about cultural awareness. Culture is a very big thing, yes? And with data
Yes.
protection, you cannot avoid culture and cultural systems. How does cultural awareness, user education, organizational transparency, all these things, how do they impact how complaints are raised and handled? This is very crucial for us. We're coming from many different cultures, many different levels of digital literacy, even user education. How do all these things impact the way complaints are raised and handled?
Okay. Thank you so much, madam, once again. As you said, cultural awareness, user education, and the organization transparency fundamentally determine whether the complaint is ever raised and whether it's how handled thereafter, this is very important question. So, from the user perspective, awareness is a key entry point because where individuals understand their right, they are likely more to file more complaint because they will be identifying the violence and take action. But in vis-a-vis, where the awareness are low, they suppress a complaint, so they create a sense of compliance with the organization. But cultural, as you said, cultural also play a very a crucial part or crucial role. And in environment like ours here in Tanzania, where there is a fear of going to the court, maybe, and there's a low trust in the institution, and also there's a very limited confidence on the remedies. People they don't they because example, I can say this in Tanzania there is no any complaint which the enforcement has been done, where a person and that data subject who filed a complaint satisfied with his or her reward. There is no any case or complaint here in Tanzania which have already resulted on the legal enforcement. There is no such a case. So this creates a low trust in institution to the individuals, particularly a data subject, but also it's limited confidence on the remedy to the individual to choose to pursue through a personal data issue or just to dump the thing. So on the organizational side, the transparency we know it's influence both value and the trajectory of a complaint. An organization that are open about their data, about their practice, responsive to concern, and clear in their communication are more likely to resolve the complaint at the earliest stage. But where this is like which are in the actual practice, many organizations they don't have a clear path, a clear what response system. So it's as I said before, and ultimately these factors they have a voice. I said before, the complaint in Tanzania started between a data controller and the data subject themselves to resolve through invocation of right. But thereafter, the matter can go to the personal data commission (PDPC), where the matter will be handled there from the issue of investigation to mediation, where mediation cannot be reached, then to the determination of that dispute. But as I said, unlikely to other jurisdictions like Kenya, Uganda, I think even in AUE, Dubai, here in Tanzania, the actual practice is very difficult. It's very different from what is in law, because the law is very clear, but in practice there's a lot of challenges. There's a lot of gaps. As I say, I identify one of the gap is between the connection between one institution and another institution. The law said the enforcement will be through judicial, but when you go in the practice, the judicial itself, there is no window for that enforcement from PDPC, which is among a very huge challenge here in Tanzania. So there is no any enforced the award which have been done here in Tanzania at all. But these factors shape not just a complaint behavior, but a credibility of the entire data protection framework. A system where the individuals are informed, are confident, and heard is more likely to be produced a meaningful and enforceable outcome. But in practice here in Tanzania, that we only see it through the act, but not in actual ground.
Mm-hmm. Thank you so much for such a comprehensive response, Abdul. And we really appreciate all of the information you've given us. Very interesting to know and to learn about that. And we're seeing how important it is for users to be educated in this. Abdul, you'll agree with me that many times it seems, even with data protection, a lot of emphasis, will go on how to understand your rights, how your data is collected, and then maybe more needs to go into practice in understanding of how complaints can be raised, how they can be handled, where to start, and where to get this resolved. One of the things what we are doing here. Yes, so thank you so much for that response. Ladies and gentlemen, please let us remember to mute our mics. Let us remember to mute our mics so that we establish order. Yes. Sadiq Omari, are you still with us? The next two questions are for you. We'd love to hear from you. Are you with us?
Yes, Madam Rahel and everybody, I'm with you, and I'm ready to respond to your question.
Thank you. Thank you so much. We have heard so much already from the other three panelists, and now to bring it to a slow conclusion, tell us about enforcement now. Tell us about the enforcement mechanisms and how they can ensure that these decisions from regulatory bodies are effectively implemented. What happens after a decision comes out, and what role do technical controls, technical entities, what roles do they play in this process? Thank you so much. Sadiq, you are on mute. You are mute. You're on mute.
Oh, sorry. I'm sorry.
Problem.
Thank you, Madam Rachel and everybody. As we all know that the issue of right enforcement is end up with the issue of enforcement, because what actual matters is the issue of accountability. So long as we take into account the issue of data protection, which is much concerned with the personal dignity, what people's are very much concerned is, do the data controller and enforcementers accountable for their mischief or for their mistake in due process of data process mechanisms. So in terms of, or particularly in the issue of enforcement, is started very immediately upon the commission award. Once the commission have delivered the award, what comes out is the issue of enforcement. And in our jurisprudence or in our jurisdiction, the institution invested with the jurisdiction to make enforcement of the award is the High Court of Tanzania. So we have many registry, but the problem is in our jurisdiction, the law is very silent on which registry you have to register your award for enforcement. That is the challenging issues in our jurisdiction. Because if you see, once the Personal Data Commission have issued an award, you have a right to enforce it. But where do you go to enforce it? Mind you, in Tanzania, we have only one registry for Personal Data Commission, which is resided in Dodoma. But we have many registers of the High Court. but the law is too general that you have to make enforcement in the High Court. So it may find out that a person in Mwanza might have an award from Personal Data Commission resided in Dodoma. And he have an access to access the same register of the High Court in Mwanza. But what actually he have to do so as he could enforce the award in his or her hand. So to be specifically on the question, we have the very clear mechanism, but it have the very clear lacunas. And what is the lacunas is the issue of the enforcement of the award upon registration of the High Court. That's the first one. But before you can find out that lacunas, you may find out the mechanism. The mechanism of lodging any issue in the High Court of Tanzania and any other courts except the primary court is through case system management. So if you found out in case management system, there is a several windows for registration of either the case, either the award. But there is no clear connection between the award or the proceedings from the Personal Data Commission in Tanzania and the Registry of the High Court. This, I can share the experience. My client, who is also the presenter, Mr. Bruno Manga, we have an award of almost 20 million. But we faced the very challenge in registration on the system, that the mechanism of making registration. What the challenge is, on all windows we have seen in the system, there is no window which recognize award from the Personal Data Commission. And even the court clerks or court assistant, they don't know even where the Personal Data Commission is located. So they don't even know where to find out the physical file. So what I could share with you is we have the very clear law, but the very clear law have the lacuna in the system management, the mechanism. In terms of mechanism, there is the lacunas, and the lacuna is specific on the connection between the judicial system and the Personal Data Commission system. They don't match. Each other have its own kind of works, and there is no any kind of connection between the two. So what is the first challenge we have faced? But also, despite of all that, there is an issue of knowledge and awareness of the judicial personnel. I'm sorry to say this, but we have found that you might lodge the issue of registration, but very unfortunately, because it's a very emerging issue, even the judicial personnel, they don't have the knowledge on how to deal with the issue of personal data. So I think, I'm not very much sure, but I think the matter of Abdul Said Namanga was the very first matter to be lodged in Personal Data Commission. But you meet the judicial personnel who they don't even know the existence of the Personal Data Commission. If they don't know the existence, means they don't know even the existence of the award. Though the law is very clear that once a person have lodged an appeal, let's assume the person have lodged an appeal. If you want to hear or to determine the appeal, you have to be on the table of the judicial, the file, the original file of the matter before the Personal Data Commission. And actually, in our jurisdiction, we have not yet depart from the physical record management. So we have a physical file and we have online file. So as I've said before, the system of the Personal Data Commission is all alone departed from the system of the Judicial Commission. So there is no clear connection. So once there is no clear connection, then what matters is the physical file to be called from the Personal Data Commission to the judiciary, so as a person who is sitting over to determine the matter could be aware of what actually happened before the commission. That is the cutting off of the communication between the judicial and the Personal Data Commission. And on my part, I could say that in issue of enforcement, you could not differentiate between the judicial and the data commission, because the issue of determination of whether the rights have been infringed is the issue of the commission. But the issue of enforcement is the issue of judicial. Then we have to have the very clear connection between the judicial and the commission. Because as I have said before, if you want the community to be confident with the institution, then what matters is the result. And there is a result of data infringement, personal data infringement, is accountability. So if you want the community to be confident and comfortable with the issue of personal data protection, the last result is the enforceability. But we have not yet seen or even see the very clear channel between the Data Protection Commission and the judicial, which is the only institution vested with jurisdiction to determine enforcement matters. That's what I could share with you, though I understand that I'm also on the issue of challenges, but if Madam Rachel will allow me, I could share more challenges, but that's the clear channel.
Yes, yes. And thank you so much. And you had already touched very well into your next question. So I'm glad you've done that, because as a last part, I would like to hear from you, and I'm sure the members in our audience would like to hear from you. What could be some solutions to this? So there's a gap, there are challenges. What could be a solution to this? And this reminds me of what Madhup had said earlier on how collaboration, now this is on complaints handling with institutions, collaborations between cybersecurity experts, organizations, and this and that. But when it comes to enforcement, what do you see as some practical, possible solutions to this, to the gaps and the challenges that you have addressed? If you may answer us in that brief, and then we will go to the final parts. Thank you.
Okay, Madam Rachel. From my experience of what I have been experiencing, that of all what I have shared, I think the possible solution, the first one, it will be to have the very clear connection. The presiding president have said, mifumo kusomana. These mechanical or technical issues have to be clear connected. The judicial
Sadiq,
and the
if you may help me, what does mifumo kusomana mean in English for the benefit of all of our listeners?
Okay, is institution, all government institution to have a clear connections. So if you file a complaint protection, it's automatically the personnel in judicial might find it out and know what really happened. That's one of the challenges I have shared, that the system of Data Protection Commission and the judicial case management system are two different systems which have no any connection. So what will be the best solution is these two institutions which are dealing with justice determination to have a very clear and direct connection. I think everybody have got me what it's my concern.
Yes.
So apart from that, the next one is the issue of awareness. In our jurisprudence, what I have acknowledged that most of persons are not yet concerned with personal data. As Mr. Abdul have said before, I think it's because of the issue of cultural issues. So what we have to take into very paramount consideration is to ensure that the last institution which is vested with jurisdiction to make a final determination regarding the accountability. Most of personnel, because it's an emerging issue, have no knowledge concerning the issue of personal data. So you may find out there is very many campaign of making people aware regarding the personal data. But how about the judicial personnel who are the last person to deal with personal data? So I think the second solution is to make the judicial personnel who are decision makers and who will raise a public confidence regarding the issue of accountability to be much aware with the issue of personal data, which is the very emerging issue. So once our government will put much efforts in making awareness for judicial personnel regarding the issue of personal data, then we'll have we'll be departing from the issue of a person to file the issue of personal data in judicial, because even the registrar will find out, no, this is not the correct forum. He will reject, and even to advise the person who raised the concern that no, you should not come here, just go to Personal Data Commission. But also on the issue of enforcement, if our judicial personnel are very much concerned with the issue of personal data, then they would have a very clear picture of what personal data means, and avoid all other issues. I think I have answered your question, Madam Rachel.
Thank you. Thank you so much. Yes, Sadiq, thank you. Thank you very much for answering the question. And I would like to do something right now because we have already spent an hour and 12 minutes. We are doing very well on time. It is in East African time, it's about 13 minutes past 3. So I thank all of our speakers and we've done really, really well. I would like to now call upon each and every one of our speakers to give last closing remarks. And also there were some other follow-up questions to ask from what we had prepared. So I'll throw this to the speakers as you give your last closing remarks before we go into our Q&A session. May I now call on Rahul again so that we may hear from Rahul? Yes, yep, Rahul, sure. Are you with us? Thank you. Thank you. In your last closing remarks, there was a question prepared for you to tell us, again, as members of the audience are listening to you, how can organizations prepare, once again, for complaint handling through stronger data protection, monitoring, and incident response frameworks? We've asked this question a lot, collaboration, how can you prepare? But tell us a little bit in your closing remarks, specifically on stronger data protection, monitoring, and incident response. I request that we all use a minute or less as we respond, and I'll move on to the next speaker. Thank you.
So, Brazil, I think the important point is we need to see it from the basic perspective. So when I say basic, right, it be it the cybersecurity, data privacy, or data governance, right? We need to always look from the basic controls which are available in any framework, right? So if I talk about the data privacy, so be GDPR or any other personal data protection law, they all talk about the privacy by design, privacy by default, right? Now, what is privacy by design, privacy by default, right? They talks about how you need to implement the data privacy controls, data privacy safeguards, basically from the starting of the process itself, where, we talk about the data minimization, we talk about the data classification, we talk about the data eraser and the other concept, or the principle which are in the data privacy. So I think we all need to go to the basic. We need to understand not only from the process perspective, but technology implementation perspective also, the privacy by design as well as the privacy by default kind of concepts, frameworks, principles which are already, implemented, and it's part of the organization DNA. I think that that's a very important thing, which we need, the organization has to cover to reduce the complaint or to reduce any kind of cybersecurity incident or data breach incident related things. The second thing which organization should be doing it, like in cybersecurity, we are having cybersecurity drills, right? In the health and safety, we are having the fire drills, right? I think in a similar way, we should be having the privacy drills where the organization, they should take care of the particular scenarios, maybe the high volume DSRs or any breach scenarios where they should test it. They should have the proper mechanisms available to test the process, the framework which are available in the organization, whether in the real situation, real scenario, how that particular process and the framework will work. So I think the privacy drill is the another important aspect and important thing which the organization should be looking. So these are the two things which I can see it from my perspective the organization should be implementing to reducing the complaints culture.
Excellent, absolutely excellent. I love that you mentioned privacy by design because I know what that is. I learned about it. I learned about it last year, so it's really wonderful, and I was glad to learn about it. Thank you so much, Rahul. Please, as I move on to the next speaker, please do share your contacts in the chat section in case anyone in the audience would like to reach out to you in future, whether it's your LinkedIn or any other place. Please do share that in the chat section. And then now to Abdul. Abdul, please give us your last closing remarks, but also there was a probing question for you. Say an organization has a system they've set up on complaint handling. How can they measure its improvements or its performance? And how can they internally measure and see how well their complaint handling system is doing well for their clients or their customers and it's being effective? As you give your closing remarks.
Okay, thank you so much. Yeah, probably I think that will be my closing remark.
Yes.
So I do really advise for organization, which are mostly being a data controller and processor, to have a clear response on the request from data subject. I have been identified that many organizations, they do not have a clear response channel on the issue of data subject request. As we know, the data subject may invoke their right through the request, but you may find out the organization, they do not have a clear system on how to deal with those requests. Sometimes they respond informally because some rights, they have a clear procedure which you have forms, a form to invoke the right, but also there is a form to respond on that invocation. But you may find out that many organizations, they either do not respond on the request from the data subject, or when they respond in informal way, which create a non-compliance in those organizations without themselves knowing it. So parting of having a DPO in the organization, it's a very good for an organization to have a clear challenge on how to deal with the claims from data subject, because these rights are come like the same as the claims. They request, they invoke the right maybe to stop maybe processing, but there must be a person who understands the procedure, who understands how to respond on which timeline. And that can without that, it's very easy for a company to be exposed on non-compliance. And when the issue reaches at that stage, it's not only the matter of whether misuse or unauthorized disclose, but it's becoming a matter of non-compliance, which will be in an evidently non-compliance. So I do really encourage the organization and the institution to have a very clear channel on how to handle and to deal with the data subject rights when they are invoked. So thank you so much, Madam Rachel.
Thank you. Thank you as well, Abdul, for those wonderful parting shots. Thank you very much. We have Madhu next. Madhu, please come and say a parting remark for us.
So yeah, my parting remarks is along the lines of our legal regulations. So the legal wording that is there on our the legal text is basically the easy part. Making it work for a real data subject with a real grievance is the harder, longer journey. So yeah, that's what the organizations should primarily focus on how do they handle grievances that comes in, how orderly it is being handled, and whether they have automated systems, whether they have actual implementation in place to identify what data is where so that they can address the data subject's grievance properly. So whether it is Tanzania or UAE, I think the primary focus should be on how you handle the grievance and how you manage your data.
Wonderful. The primary focus should be how you handle the grievance and how you handle the data. Thank you so very much. Sadiki, last but not least, your parting and closing remarks as we open up the floor for questions. Welcome. In less than a minute, Sadiq.
Okay, Madam Lecture, thank you. I think everybody knows that personal data is much concerned with personal dignity. The very important human right. However, the issue of enforcement, once it's faced in inefficient mechanisms, then the whole process of data protection is inaccurate, or the whole public will not be concerned with the issue of personal data. So my concern is, once we are dealing with personal data, we have to make sure in knowledge that that is a personal dignity. And the personal dignity lasts with the issue of accountability. So the issue of enforcement is the very vital part in the process of data protection mechanisms. So taking into account our jurisprudence in Tanzania, we think you have a long way to go to improve the issue of enforcement, very particularly enforcement against the government, because the government institutions are among of the most and major personal data collector, but the law is very silent on the issue of enforcement against the government. And the government institutions are the most and major institution which lead the issue of personal data, because are the institutions which own and govern the very vital personal data. So I would like to recommend for those who have those institutions that the issue of enforcement have to be taken into very paramount consideration, because that's where we will establish the public trust on the data protection. That's all I can say.
Okay, thank you very much to all of our speakers. Thank you very much. Ladies and gentlemen, please give them a round of applause. They have done so well, absolutely well. We have questions. I'll give you a round of applause. All of you, Rahul, Madhup, Sadiq, Abdul, I'm going to give you a round of applause. Excellent, excellent presentations. Yes, we already have about 4 questions in the chat section. Please do allow me to read them and so that we can respond to them. I know the first question is looking more on GDPR, but the other 3 questions were specific to the Tanzanian jurisdiction. So for the first question from Mariam, I would kindly ask either Rahul or Madhup, you can answer this. And Mariam has asked, as our current data protection laws, like GDPR style frameworks, are they strong enough to handle modern digital tracking and AI systems? So that's from Mariam. And then just very quickly, Abdul and Sadiq, if you can take, there's one question from Mary that asks, is the PDPC, the commission, the Tanzanian commission, is the award similar to an arbitration award? If so, can it be registered with the High Court commercial division as required by the law? Abdul and Sadiq, please take note of this. One of you can answer it. And then there are a few questions from Muhammad as well. I will read this also after we answer the first two questions. And then there is a question from Mateos, which also asks, what minimum governance structure and technology baseline should an organization implement to ensure effective PDPC commission compliance in complaint handling, investigation, and enforcement? And he requests, please answer my question by considering the financial institutes or financial sector. Okay, so let's start with Rahul or Madhu. The question from Mariam Karume. Are current data protection laws like GDPR style frameworks, are they strong enough to handle modern digital tracking and AI systems? Thank you.
Yep. So, Madam, thanks a lot for this question, and it's a very interesting question, right? So, if we see GDPR, right, GDPR is already a very forward-looking framework or the law, right, where it talks about anything which is talking about the automated decisioning, automated, the marketing perspective. So, I think it's very forward-looking. It covers the technology, digital tracking, and the technology-related issues. If we specifically talk about the AI systems, right, so we have to see it, the new standards which are, or the laws which are coming in the different regions, right? So if we talk about EU AI Act, which specifically covers anything which is coming from the AI system perspective, which complement the GDPR, which also talks about the privacy related issues. If we talk about EU perspective, then Dubai is also having its own AI Act. They are having the PDPL, right? So these, I think, standards, the laws which are there, be it GDPR or EUI Act or the PDPL or Dubai AI Act, they complement each other. And I think what I have seen the trend in the different regulation perspective, right? This is how it is going, be it Africa, be it Asia or any other Europe or US region. There are law which is there for the data privacy perspective, and any issues which are coming from the AI system, they're already tackling it in the AI Act. I hope that I give the answer to your question.
Thank you, Rahul, for that. Thank you so much for responding. May I now call upon either Abdul or Sadiq to answer the question from Mary Chami. Mary would like to know, is the PDPC, the Tanzania Commission, is the award similar to an arbitration award? And if so, can it be registered with the High Court's Commercial Division as required by the law?
Okay, thank you so much. This is very good question and a very interesting one. I understand why Mary asked this question, because in our law, when you go in a specific provision which give a person a right to enforce a award, it says that the award should be enforced in the High Court as if is an award from Arbitration Act. But that is only on the recognition. On how the High Court have to recognize the award, they recognize that award as if it's the award from the Arbitration Act. But the actual execution is done as a normal or other suit. Like when you are doing an enforcement, you do the enforcement in any High Court. It's not must to be in the commercial, because this is not a award from arbitration. But when the High Court have to recognize that award, because before the actual enforcement, the first thing the High Court have to recognize the award from the PDPC. So this process of recognizing this award, the High Court have to recognize the award as if it's the award from the Arbitration Act. But it is not that this award are the same from that award from the arbitral award. No, this is not a arbitral award. This is a different kind of thing. But when it's come the actual then enforcement after recognition, we go to the Civil Procedure Code for execution as a normal civil suit. I think I'll be answering Ms. Mary clear.
Thank you so much for that response. Next, we have Muhammad. Muhammad had about 4 questions, and I think either of the speakers from either of the jurisdictions can answer at least the first one. Now, this is about employment matters. Reference checks are usually done, says Muhammad. The information shared about a candidate by previous employers is usually not shared with the candidate. Is this correct? That's number one. And then number two, as per the data protection laws in Tanzania, can a candidate who is a data subject request for this information, maybe emails, recorded phone calls from the employer or the recruiting firm? So if there is any deviation between what is said and the actual clearance documents of the employee can then address any anomalies with the employer. That's question number two. And then question three, can the employer or recruiting company deny to share the information, reference check information, on grounds of breach of privacy and confidentiality through data protection laws, or allow a data subject to request for it and be granted this information? Can the candidate approach PDPC and file a complaint on the same? Our esteemed speakers, I believe you have heard Mohammed's question. Who may be ready to respond? At least we start with question one, very briefly, as there are other questions coming up.
Sorry, can you repeat the question number one?
Okay. The information shared about a candidate by a previous employer is usually not shared with the candidates. Is this correct? Mohammed, are you meaning if information is shared from a previous employer to a new employer? If you may clarify, Mohammed. Mohammed, are you able to unmute?
Yes.
Yes.
That's specifically,
welcome.
That's my question, that you might probably having a new employer, or you're searching for employment, or you're already with an existing employment. And for one reason or another, your employment is prejudiced due to probably information shared by previous employers, which basically have no grounds, as this does happen in the employment sector. So my question is it correct an information is shared by a former employer to an existing employer, and that is not shared with the employee? Is that correct?
Okay, thank you. Thank you so much. Abdul, is that clear now? Are you able to respond?
Okay, Madam Rachel, if you would allow me, I would respond.
Yes. Welcome.
Okay, Mr. Muhammad have raised a very critical question, and I think the answer on that question, we have to be direct on the mischief behind the enactment of the Personal Data Protection Act, regardless of the jurisdiction. But what we have to note in mind is the jurisprudence behind. Prior to the enactment of these laws, I think nobody was able to think about those sharing of information. He's very right. There is that kind of trend that a former employer would be requested to share the personal information, which tends to be the personal data, with the intended employer. That is the current trending, which have been the experience of the employers before the emerging of personal data. So on my perspection view, is that is not correct. Because at the first instance, when I give you my datas, whatever was my age, my experience, whatever, I give you as you, not for the purpose of sharing. That's how we come to imagine the issue of transparency. That's why you as a data subject, you have a right to rectify, to stop, and whatsoever. So to be very short, that first it's not correct for the former employer to share your personal data without prior consent, because you are the owner of your own personal data. You are the owner. Hence, if you are the owner, you are the one to decide who have the access of my personal data. So if to harmonize the situation, there have to be a clear channel between the former employer and the intended employer. The intended employer, in his or her poster which welcome a person to request for the employment, have to state out that you raise the right for me to seek for your information from your former employer. Unless otherwise, if that have been conducted without your prior consent, then that is clear. I could say that is a very clear breach of principles of personal data. I don't think if I have responded to Mohammed's question clearly.
Yeah, I got you.
So,
Yeah, thanks for the clarity.
Sadiq, I think you have covered the answer in a very well manner, especially when we talk about the consent part. That is very important. Like what consent the employees they have granted for the employees, right? The important aspect, which also we have to see it from the transparency and the lawfulness perspective. One of the principle which is there in the privacy, right? So, like, what is the purpose why the employees they are collecting the employers they are collecting the employees data? I think that is very important. What is the purpose behind it, and how long they are going to store it? And if they are having the purpose where they are going to share it with any next employer, so I think that has to be clearly articulated in their agreement, in their purpose, which they are collecting the information.
Thank you. Thank you for that addition also, Rahul, and for responding, Sadiq. Thank you so much. Mohammed had also asked, so can the candidates or the data subject request for this information? Which, Mohammed, if I got you correctly, it's this information that is being transferred from the former employer to the existing employer, yes?
Yes, yes.
Okay, so you want to know if the
Yes.
candidate can request for this information that they're sharing between each other?
Yes,
Okay.
yes.
Okay, I think I'll respond on that. Yeah, he or she can, through the invocation of right, as I said before, there is a certain right called a right to stop processing that are likely to cause damage. So if that processing so if he feel that processing of his or her personal data in that intended employer, it's likely to cause damage. So that employee have the right to invoke the right to prevent processing that might cause damage through the invocation of right. So he can send the request to that intended employer to stop the processing of he or her personal data. The law is very clear that within 72 hours, data corrector or data controller or processor have to stop before even to decide whether this request is right or not. But within 72 hours, which is 3 days, he have to stop. This is an obligation from the law. And from that, within 7 days, that data controller or processor have to give the response. So within 72 hours, that personal data have to be stopped to being processing, wherever that processing is likely to cause damage or not. But the decision on that is to say that this personal data processing may cause a damage can be given out after 7 days. So yes, he or she can.
Thank you, Abdul, with that. And it goes really well with the next question, the last question that Mohammed had. Now, can the employer or the recruiting firm, can they deny sharing this information and say, no, we won't give it to you because of breach of privacy or confidentiality? This is what Mohammed had wanted to know. And yes, can they deny giving this information? And if so, can the candidate approach the commission in Tanzania and file a complaint on the same?
If I understand that the intended employer denied it to give the personal data of the certain data subject. Is that right?
Yes,
Is when the data
oh yeah, Mohammed, welcome. Mohammed, you can
Yeah.
respond.
Yes. The intended employer denied to grant access to the probably emails or polls during the reference check to the employee who is requested for that rights under data subject. So then what happens in that case? Can you approach the PDPC and file a complaint? And two, can the employer really decline that request?
Okay, I understand you well. First of all, a matter of whether to accept or reject the concept, the request, it's depend on the data controller and the processors themselves. But they can, even the law understand that the law itself, there are certain provision which state the employer have to give the data controller or processor have to give the determination from the request whether to reject or to accept. So the law itself will understand that it can either reject or accept. But once employer, or in this context, mini employee, which in this context is the data subject, is aggrieved with that decision, he have a right to go to escalate the matter to the commission. And here it's very crucial part because the right of access has no clear procedure. As I said before, there is certain right in the PDPA, but there is a few rights which have a clear procedure under the personal data collection and the processing regulation. So, example, in that right, it will invoke a right to present, to preserve. Right to stop processing of personal data that are likely to cause damage. When you are aggrieved, the law give you a timeline of 14 days, only 14 days to escalate the matter to the commission. And when this 14 days has expired, the law also gives the right to the certain data controller or processor to continue to processing that personal data. So yes, he or she can escalate the matter to the commission if he or she feels aggrieved from the decision of the data controller or processor. But at the same time, the law also gives the room for data controller or processor either to accept or to deny the request. Thank you.
Thank you. Thank you so much for your response, Abdul, on that. Sadiq, you have your mic on. Did you want to add something on this?
Yeah, of course, I would like to have something.
Very briefly, please, in 30 seconds, so that we can get to the other questions.
Okay.
Yes.
Yeah, the issue of denial or whatsoever it could be started with the issue of employment contract. So for those who are employees, before you are going to sign a contract, make sure that there is a clause concerning your personal data. Because you might find out that you have signed a contract which allow your current employer to share your data. So what I could add is for those who intend or are intentional need to be employed, before you sign a contract, take into account the issue of data, personal data issues have to be among of the clauses in the employment contract. You have to be very careful about your personal data. So before you are going to the issue of merit on whether it could be possible to deny or whatsoever, the issue of to deny or to accept started with the issue of the contract clauses. If you have allowed the employer to share your data, you might lodge a complaint to prohibit him. But so long as you have accepted at the time when you sign the contract, that is when you rest your personal right to the employer. So I would like to advise and to encourage employees before you sign the contract, despite of the issue of remuneration whatsoever, kindly make sure there is a clause concerning your personal data, because that is your dignity. Thank you.
Thank you. Thank you so much for the wonderful responses. The engagement is really hot, really engaging. And I do have Mr. Samuel from the audience who would like to chime in on this conversation about employer, candidate, employee matters with data protection. Please, Mr. Samuel Mujaku, may you kindly come and contribute in 30 seconds. Thank you. Mr. Samuel?
Thank you. Thank you, madam. I think I can contribute something on this.
Yes, yes.
And I like to take it in a court of law perspective. I think as a data subject, person who seems to have been aggrieved may have a chance to ask for the disclosure of the data from maybe the employer, as it is stated before. And when you take it to the court perspective, I think that there's this thing called the interrogatories and discovery. You can apply through discovery to let the other side to dispose or to disclose the information that you think they can help you to hold your case. But in releasing the data concerned, it can be possible for the other side to release the information or to deny to release the information. These are this thing called the phishing. I think phishing deviation, and the many companies or the employers are always hesitating to disclose the information because of that. They think they'll be insecure and all that. But when you're requesting for such data information, you have to be sure that it is the information that first you think that the person that you're requesting to disclose, he is the person who is holding the data, but also that data information will help you in what you're about to do. Maybe if it's a case or another thing, but it's not. You should not request for the information for the data in having other intentions or that. I just wanted to contribute something on that.
Okay, and thank you so much. We truly value your contribution to our team in Sandbox Security. If you're listening to this, maybe we may need to have a webinar on employment data protection or data protection in the employment sector. Yes, Rahul, Madhup, Amrita, and everyone. I'm already getting more ideas on this. Yes.
Definitely.
Right? Yeah, this could take a whole day. Yes. So we will
Participant can also reach out to us.
Yes.
Rachel, they can have if they have any questions. Yeah, definitely.
Absolutely. Thank you so much. I know we have about maybe 2 other questions, and the next one is from Mateos. And I know though he referred PDPC, we'd love to hear from UAE. Madhup can respond to this also. What minimum governance structure and technology baseline should an organization implement to ensure effective PDPC compliance in complaint handling, investigation, and enforcement? Now, looking specifically at the financial sector. Would any of the speakers like to answer this, or if you need more clarification?
See, I can definitely,
Okay.
give the answer to this question, but not from the PDPC perspective, largely from the general data privacy perspective. It's totally depend upon the organization, what kind of technology they need to implement. And especially if we talk about the financial sector, because I have worked in a multiple financial sector as an in-house, the SME in different areas, be it cybersecurity, data privacy. I can say that, yes, you need to have some kind of baseline technology implementation. So if we talk about, because see, financial institutions are largely the big organizations, right, where they are having the thousands of customers, where if the complaints are coming, if any kind of requests are coming from customer, right, they have to comply with with this. So the technology, as I mentioned previously, like the technology is very important, but be it on the complaint management, be it on the cookies management, be it on the data leakage prevention perspective, data classification perspective, because doing these things manually is a mammoth task. You cannot do it manually. You need to have the automation available. See the simple thing, like if you have to do the consent management or cookie management on your website or one or two challenge, imagine that thousands of customer, they are visiting your website on a everyday basis. How you are going to do it manually, right? So you need to have that technology implemented. But again, the baseline, that's something which organization has to define. Organization has to see it from their risk perspective, from the regulatory requirement perspective, what kind of technology landscape they have to implement. I hope that I am able to give the answers to this question.
Thank you. Thank you for that response. Mateus, I hope you've heard that response. And I know you wanted to also hear from the PDPC side. Sadiq or Abdul, would either of you be able to respond to Mateus on this question?
Kindly, if you could remind, you could tell me more about the question, please, kindly.
Okay.
Just shortly.
Okay, Mateus would like to know about minimum governance structures and technology baseline, the minimum that an organization should implement to ensure effective PDPC compliance when it comes to complaint handling, investigation, and enforcement, looking at the financial sector.
Okay, like any other sectors, the issue of compliance needs expertise. So on my side, what I could advise any other institutional financial institutions, the first steps they will have to take is to ensure that on board they have a person or they have a personnels who have personal data protection knowledge. That is DPO. So that is inevitable. Regardless of the law, have been very clear and very not limited in terms of the qualifications. But on my side, what I could advise is data processors have to inboard data persons expert on board. That's the first step. The next one is not to delay in response, is to ensure that all concerns regarding data rights are responded in time, because there is a time limitation. And the law is very clear that once you infringe a personal data within some sort of time, you have to respond. So first, for me, is to have a personnel who is expert in personal data. Second, it's to have a operational strategies which allows the data personnel to respond and to be accountable into data person concerns on time, because time matters in every litigations.
Thank you. Thank you both for that response. Abdul, did you want to?
Sorry. I can comment on that point a little bit.
Yes.
I think apart from those factors, which Sadiq have already mentioned, but I also think it is very important for the institution or organization to have a clear documentations, to have a clear policies, to have a clear disclaimers. Maybe if they're using cameras and whatever, they should have a clear documentation in each and everything, even a clear contract, as Sadiq has already mentioned before, that the organization, employer and employee relationship to their contract should be clear on how the data is managed, how data is handled, and whatever. So my point is, apart from those steps and the factors that Sadiq has mentioned, but it's very important for any institution or organization to have a clear documentation regarding the personal data protection. Thank you so much.
Well done. Well done. Thank you so much, Abdul. We also have a question from Fatma. Rahul, I don't know if this is the one you're responding to. Fatma would like to know if in the United Arab Emirates, if there's a timeline for filing a complaint on data protection. Fatma, if you are there, I don't know if you're referring to a complaint to a commission or an authority. Fatma, if you're still in the call. But either way, Rahul, as Fatma is coming in, she would like to know, or Madhup also, if in the UAE there's a timeline for filing a complaint on data protection. I assume this is filing a complaint with the regulator.
See, I'm not sure about filing a complaint to the regulator. There is timeline because that I haven't seen, but definitely there is a timeline, like within what time the company should be responding to that particular complaint if any customer is having or any DSR is there, right? So which is, within 30 calendar days, the organization has to respond to that particular query which is coming from the client or an individual perspective.
Oh, okay. So if it's for a client, a data subject requests, it's within
Yeah,
1 month.
Yeah, that is something which you have to, yeah.
Okay, okay. Miss Fatma, let me know if that answers your question or if you'd like more clarification later on. There is another question from Josh Mwangasa. This is very interesting. How does data commission work together with law enforcement agencies like the police? Welcome for responding.
Okay, so I will respond on that. From my perspective, the Data Protection Act (PDPA) have certain offenses which criminalize some act to be a criminal liability, not just like other liability. And so I think this is where Personal Data Protection Commission act together with agents like police and the NPS, National Prosecution Services, on this regard, because when this criminal liability arises, it goes directly on the criminal issues, which are basically starting with the police force, and they are not starting directly with personal data protection. So if you are going through the Personal Data Protection Act, the PDPA, you might find out there is several offenses which criminalize the personal data violation to be a criminal act. So in that regard, I think that is where there is a trajectory between a Personal Data Protection Commission together with forces like police forces. That is what I can say.
Thank you. Thank you so much. From Sandbox Security, Madhup or Rahul, would you also like to respond to this? This is our last question in the chat section. If at all. All right. Okay.
Sure, I will take Rachel. So just to add this, like, if I understood the question correctly, so Josh is asking like how data commission can work together with law enforcement agencies like police, right? So I think we need to see it from the violation perspective, what kind of different, the violation is there. In my experience, whatever I haven't seen till now, like, where there is any requirement, because largely, I have worked in the private sector, so I haven't seen where any issue has been goes to the public or any other, law enforcement agencies. But I think that the organization has to take on case by case basis. The data commission, they also have to take it on the case by case basis, whether there is any criminal activity which is involved, and they need to have the law enforcement agencies get involved with this.
All right. All right. Well understood. Well understood. One other probing question, Uti Mwangamba would like to know some examples of those offenses. I believe these were the ones that Abdul may have mentioned, offenses, or if anyone knows of any examples to share.
Okay, but you will allow me to look on the act because I don't have that on my mind. There is the offense of unlawful disclosure of personal data under Section 60 of the Personal Data Protection Act. But also there is an offense on unlawful destruction and deletion, cancellation, or alteration of personal data. But also there is an offense which can be done by the a company or its officer of the company. So the offense basically there is several offense, but also there is offense even if you do not comply with the personal data protection collection and the processing regulation. That is the offense. Wherever regulation you are not you are not in the track with any regulation in that regulation, that is an offense, including registration. So if you are not registered by the Personal Data Protection Act, by the Personal Data Protection Commission, that is also an offense under the Personal Data Collection and the Processing Regulation. I don't remember well the certain regulation about this, but I will put it when I have already seen it.
Okay. And Abdul, also, if you may share your contacts in the chat section for Uti, maybe he can reach out to you via email or on LinkedIn to discuss this matter more. All right.
Okay.
I don't see any other questions in the chat section, and we are already at 2 hours in. I give room to one last question, maybe from the audience, if anyone would like to raise their hands. One very last question before we close this meeting for today. Anyone else with any burning questions? Final one? Okay, Hillary is asking, what is the primary objective of personal data protection in the United Arab Emirates?
I think the primary objective, which any other privacy standards are there, the same as in the UAE also, to protect or safeguards the customer or the individual interest. I think that is what the primary objective is, and to give more power to the customer, which is it's very important, so they can have the control on their information, how the organization they are processing their personal information. I think that is what the primary objective is.
Okay, Hillary, there is your response. Thank you so much on that. Ladies and gentlemen, I now would like to bring this meeting to a close so that we can allow you to continue with other activities of the day. Please once again give a huge round of applause to all of our speakers, to Rahul, to Abdul, to Sadiq, to Madhup, and a special round of applause to our partners, Sandbox Security, and to the Tanzania Privacy Professionals Association. This has been our first webinar of 2026, and we are so glad we have done it, and it has been wonderful. Thank you for staying with us after 2 hours, and thank you for engaging in this conversation. We do hope that you will follow our social media pages. Fatma had shared our WhatsApp group for the Tanzania Privacy Professionals Association. We'll share more contacts with for Sandbox Security, and please look out for more events that we will be doing in future. And thank you once again for being with us. We hope you stay well, and let us stay connected and have a wonderful rest of the afternoon. This has brought us to the end of the webinar.
Thank you, Rachel.
Thank you so much.
Thank you, everyone.
Thanks a lot, Rachel.
Thank you, everyone.
Thank you, Rachel.
Thank you,
Thank you, everyone.
I'm going to stop the recording.
Thank you, everyone.